that this bench is part of the conspiracy?
My Lord, may I object to that? Ahmed Nasir is not the law.
Your Lordship.
He speaks not to the law. Ahmed Nasir has also an affidavit. He is not a witness, my Lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
May I answer that, Your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the president's lawyer says, we cannot receive justice. That is the standard.
Ahmed Nasir says that this court will quash the impeachment of Brigadier.
To respond.
No, but the point is, he then speaks in your favor.
Yes.
Pick that line.
Let him respond. You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rules 47, is of paramount importance and something that cannot be ignored. Why did the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that would wish to expunge paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Macharia will highlight on the authority with the authority in support of my submissions and those of Kibe.
Sorry, just a slight clarification on expansion. Paragraphs 10 and 16, if I had proper.
Yes, that's correct.
Of supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expunge paragraph 16,
Can you cover it in your response, please?
I may, but if you expunge 16, I've abundantly that there is no application before you. if you expunge paragraph 16 from the affidavit, there is no application as being urged upon you. So we need to know this clarification. Let's not just insult it.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expurge is paragraph 16.
Which affidavit? By who? It is the affidavit of the 22nd of November. Those that are 16 for these tutorials that is getting for this.
Order, please read as paragraph 10. Your Lordship, I wish to say that most respectively, I wish to say no more in respect to the paragraph. This is a direction from court. Read paragraph 10 and paragraph 16. Paragraph 16, paragraph 10 first. May I have some peace here? No. Listen, please, listen. Who is in conduct? Listen. Bananjiro. Yes, Your Lordship. You have applied to expunge paragraphs 10 and paragraph 16. Yes, Your Lordship. Can you read those paragraphs which you intend to expunge? Your Lordship, paragraph 16 says that paragraph 10. Your Lordship, may I take note that these paragraphs have been expunged? No, we have not expunged those paragraphs. It is your application. Them. The petitioners have credible information that Honorable Murima is a close associate to the proposed the President, one Mr. Kidore Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is conflicted as she should recuse herself, as she was Mr. Kidore Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
Professor, you will have your time to submit, sir. And that's why I'm expanding it. That's why I'm expanding this paragraph. In a ruling, because application has been made and the response is there, but we decline the invitation to expand
expunged those paragraphs, they will remain as part of the record. Dr. Kamuna, we would appreciate if you want to address us in the course of the as in you are submitting. Is that the position?
Yes,
okay, proceed.
I have a position, no question is that
are you supporting the motion?
I'm supporting my land friends complain to you as my friends.
To my senior lords, I'll take about 15 minutes. Massively, my issues are issues of law. They will not incite any shooting up from a respondent, or should not. My lords, I have not under your leadership. I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Pranjikerai versus Veruma Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. Led it to this decision was the question of bias. I invite my lords and your leadership to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal had afresh. I invite you now to go to paragraph 9. We've done back-to-back a photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talokar Singh Rai. The judgment in the terms of and we accordingly invoke the court's residual jurisdiction to correct that injustice by reviewing the judgment and setting aside with all the consequential orders. Now, my learned friend Mr. Kibe has referred you to a passage that my good and learned friends, the respondents, insisted must be read. And this is a question of the attendance of a wedding where gifts are shared by a judge who the gifts are received by a judge by a party who is before this court. We are before this court because the first petitioner was impeached in the Senate. The Speaker of that Senate is a party in this case. In the document presented by Mr. Kibe, the Speaker describes the judge, and there's nothing wrong with having
as I should say, I need to say this. He says, my long-time friend. This is what he says. Now, we found a decision, and I've shared it with you. This is the case of Naveen, where on all fours, a similar situation occurred. And I invite the court now to look at paragraph 70 and allow me to read this, because I won't be reading anything else after I read this. This is what the court, this, as I said, is Naveen Prai versus Virunga Limited and others. I begin to read. I say paragraph 70, please. Code of conduct. I'm reading from paragraph 70. In this matter, the third respondent declined to recuse himself. This was a matter of an arbitrator appointed under Article 159. Declined to recuse himself on the basis that the relationship between him and the counsel for the first and second respondents was a professional one. This court, however, takes judicial notice of the fact that in the Kenyan context, invitations of colleagues to weddings is extended to those that one considers close, and such invites are not extended to all and sundry. Had that been the case, then the third respondent could have as well extended the invite to the counsel for the applicant, who is an advocate just like him. Given the circumstances, this court arrives at the inevitable conclusion that apart from being a professional colleague, the third respondent and counsel for the first and second respondents are friends. And that is the perception that any reasonable, objective, informed member of society would reach based on the circumstances of this case. I continue, paragraph 71. As counsel for the applicant stated, it is common knowledge that there is the custom for invited guests to give gifts at a wedding, exactly as happened in the case Mr. Kibe showed you. In this case, apart from the third respondent and the counsel for the first and second respondents, the applicants and their counsel will never know if the counsel for the first and second respondents was a gift-bearing guest at the traditional wedding or not. In this case, we know, because the photograph depicts a gift. It, however, boils down to the failure by the third respondent to disclose to the applicants and the counsel that he intended to invite the counsel for the first and second respondents to his traditional wedding and seek their views on the same. I need to emphasize that the real issue here is not that a wedding was attended. It is that that issue was not disclosed prior to the hearing and dismissal of an application in this matter and the continued conduct of these proceedings. I continue. Bearing in mind the final nature of arbitral awards, which can only be set aside upon a litigant satisfying the conditions stipulated under Section 35 of the Arbitration Act, the need for disclosure becomes even more critical. Paragraph 72. In S versus Roberts, the court stated that the apprehension be that of the reasonable person in the position of the litigant and that is based on reasonable grounds. I continue at paragraph 73. The counsel for the first and second respondents has stated that since he and the third respondent are arbitrators who have served at the Chartered Institute of Arbitrators, Kenya branch, as chairman and vice chairman of the institute respectively, during the same tenure, they were bound to interact or have interacted in the Chartered Institute of Arbitrator events, trainings, board meetings, and members' welfare gatherings while discharging the professional mandate. I do agree that the above events are professional in nature. However, weddings are personal events where families, friends, and close colleagues are invited. The lack of disclosure by the third respondent that he had invited the counsel for the first and second respondents to his traditional wedding is one that leads to the perception of bias. Due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence that applicants have that he will be neutral when it comes to the hearing and determination of the arbitral proceedings before him involving the parties hearing. In conclusion, this court holds that there was lack of transparency on the part of the third respondent, and he should have done the honorable thing when he was requested through an application to challenge to recuse himself from the arbitral proceedings in nature. This court finds that the justifiable doubts have risen as the third respondent's impartiality and independence, and the same have been proved by the applicants. This is a decision, and the only one we could find, that addresses on all fours the issue that confronts this court. I ask this court to find favor with this decision, to recuse itself, and I do so with tremendous respect. It's just that the nature of the matter, the nature of the issues, and the perception as such as are captured in that decision. Recusal will be the only thing that will do justice to not only the applicant before you, but to the court itself. Thank you for the privilege of your attention, for your time. Unless you have any questions, I'll rest at that point. And you have. I sent it. Soft copy. You have.
Is my humble submission that the lordships must exercise flexibility. The usual case law relating to recusal is inapplicable in instant case. As a matter of fact, I will say to you very respectfully, if there are parties, and these are, who do not want or who do not wish to see you hear this matter. Please walk out. You're not the only judges in the country. Let another panel of judges be appointed to hear this matter. If I may say so very respectfully, to refer to my own history. When you reach my age, you keep on looking at your history. I remember there were one or two expatriate judges, colonial judges. The moment you say to him, with your lordship, I would like you to hear this matter. I want you to recuse yourself. His response was, okay, if you don't want to hear this case, let another judge hear it. That is the attitude you should take. Those of us who have had the advantage of receiving higher education know when giving introduction to philosophy, they are taught that perception, the first course you take is perception and reality. Perception and reality. When you are studying philosophy, perception is a very important concept when it comes to the arena of politics. Reality may be completely different. Indeed, I believe it is different in the case before the lordships. I appear before you very often. I've never entertained any idea about your standing in relation to justice. But the perception now that has been painted by my able, learned friends, clients, Mr. Mbegwamville, Mr. Kiba, and Mr. Macharia, that there is a sizable portion of the Kenyan population which will not be happy to hear you sit into this case at all. And we have demand the lordships very respectfully. Impeachment is politics of the country. There's no way you can move away from that at all. I would respectfully refer you to a book I've taken the trouble to read.
Sorry for the interruption. You are muted again. Perhaps you will be unmuted so that you follow the proceedings.
I wonder why it has happened in respect of Khamini. Can I speak now? Can I speak?
Yes, you will be muted.
Yes. Your Honor, there is a book here, Politics of Presidential Impeachment. Politics of Presidential Impeachment. I've taken the trouble during the weekends to read this book. Impeachment is politics of the country. There's no way you can remove it from the politics of the country at all. And that's why I'm telling you very respectfully that as you have been told, there are some people who feel very strongly that you should not hear this case. Get out! Let them get out of judges to hear the case. They have no vested interest in the matter. It's not easy for you to name the case when other people don't want you to hear the case at all. May I remind you that when we are hearing impeachment cases, advocates should be able to think broadly and bring to your notice the culture of the people that we are serving. There is a little song that is sung by a little girl in Kenya. To those of us who listen to the Kenyan radio may have heard of it. She says in Kiswahili, Kenya ni nchi ya watu wa akili kidogo. She says very beautifully, Kenya ni nchi ya watu kidogo, na wanataka kitu kidogo ndio fanye kitu. Majority of our people are not the people who are in this courtroom at all. Majority of our people are people who have not had the advantage of receiving the education, the training that the judges and the advocates and the members who are in this room at all. And as one of my friends very ably pointed out, majority of the people believe that the case before you has been engineered by the politics of the country. Indeed, if some of them believe that your lordships cannot hear them, again, I say to you very, very respectfully, you stand to lose nothing. You better leave the case, let other people hear the case, and you will continue to maintain your name. My lords, to go back to the politics of impeachment, this matter was first heard in the National Assembly. The National Assembly very overwhelmingly stated that the Deputy President had been impeached. It was then referred to the Senate, and the Senate again stated very overwhelmingly that the Deputy President was guilty and convicted him accordingly. My lords, the story is that one hears in the streets of Nairobi. The story is that one hears elsewhere. You cannot afford to ignore it. Stories like members of parliament were each given a handsome amount of money. That may be so or may not be so. It doesn't matter. They have made the point that the members of parliament received bribes and they handed down a decision which majority of people believe that it was a corrupt decision. You cannot afford to ignore that. Now, when you go to the Senate, they are told the same thing, that the members of the Senate received money in what is called white partial or something of the sort, white partial. They received money from known people. Again, you cannot afford to do that at all. Now, when we come to judiciary, they expect the best. They expect people who have got integrity. They expect people who can hear them and whom they cannot suspect at all. But if then they are suspecting some people, whether truthfully, whether honestly or not, it is my humble submission, the natural thing as a judge, if I was sitting where the lordships are sitting, I would say, as Khaminwa, I'm walking out. Do not sit. It is the judiciary that people have got confidence in. That I may remind you, lordships, very respectfully. It is the judiciary that the people of Kenya actually have respect for. It is the judiciary, the judges, that people think that it can be good in Kenya. When we had a problem in the year 2007, it is the judiciary that served the country. When we had a problem recently during the time of President Uhuru Kenyatta, and the matter went to the Supreme Court, it is again the judiciary that served the country. Now, if you find that people now are questioning the very institution of the judiciary, it is my humble submission that as a judge, move out. Say thank you and moving out. That does not necessarily mean that there is something wrong with you at all. And as I've said, my lords, I've spent many years appearing before your lordship with the Justice Ogola in Mombasa. At no time did anybody ever open his mouth and say to me that, Khaminwa, this Justice Ogola is this, is this, is this, is this. Nobody ever did it. My Lord Mr. Justice Mulima, I've had the privilege of appearing before you in many cases. There are cases where I have given you rulings. There are cases where you have not given me orders at all. But at no stage did I ever entertain an idea that there is something wrong with Justice Mulima. We have confidence in all of you. But now we have this concept of perception. There are some people who feel very strongly that Justice Ogola should be out. Justice Mulima should be out. I let you judge, may I say I'm leaving you, I'm not discriminating against you. I'm one who has fought for the rights of women. And I kept on shouting very loudly that we want women judges. I have not had the fortune of appearing before you very often.
Actually, you have on a couple of times.
I'm sorry, my memory is letting me down. But my Lord, may I say, I have had the opportunity of appearing before you. And may I say this with my Lord, if you go and check the Judicial Service Commission records, you will not find a single letter from John Khaminwa complaining against any judge. I have never done such a thing at all. It's because I've got confidence in our judges. I've got confidence in our magistrate that they deliver justice. But I'm just saying you, my lords and my lady, if at this time we have some people who feel very strongly in the camp because they may not get justice before you at all, please walk out. Don't continue to hear the case. And indeed the people who are saying that your lordships or my lady should not hear this case, when we are speaking, you cannot really criticize them. They have got some valid complaints. My my lord, United States of America, which I had the opportunity and the privilege of getting and studying their jurisprudence, they gave me additional legal education. United States of America, which has an impeachment provisions like Kenya. For 200 years, there is no president or deputy president who has been impeached and the impeachment has succeeded. None at all. None at all. Kenya, a young country which got the first constitution involving impeachment provisions, came into operation in 2010, and in 2024 we are now being told the deputy president has been impeached successfully, has been found guilty. Is it unreasonable to suspect there is something wrong? Is it unreasonable to suspect that someone is doing something wrong? Gachagua may be a nut, may not be probably properly educated, but he is a deputy president of the Republic of Kenya. Why should he be the first one within such a short time to be impeached in the country? Can't you suspect there is something wrong, that you are not doing some things properly? That America, which has had impeachment provisions for 200 years, has never successfully convicted someone for impeachment after a politician.
Thank you, Dr. Kabila. Thank you very much.
May I say thank you, but may I say with your respect, I would appreciate if you would uphold my submissions. Thank you.
Just 2 minutes, fellows. In considering this application for recusal, I agree that you bear in mind the following. One, your brother, Mr. Justice Gachagua, your brother, Mr. Justice Mugambi, your brother, Mr. Justice Mwongo, sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record before, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised against. So for that reason alone, please accede to recusing yourselves so that another bench will be set up to adjudicate those issues. I thank you.
much. My name is Gachagua. I would like to talk about just 3 aspects on the subject of recusal, and I'll be making reference to the materials I believe will be circulated. That's a recent Supreme Court decision delivered on 11th of October 2024. Let me make arrangements so that Your Lordship, on my right and on my left, counsel who are involved in this matter where the Supreme Court was asked to recuse itself. Which case? This is Dari Limited and 5 others versus East African Development Bank. Mr. Namuji and Senior Counsel Paul Mitombe were on the same side, but today they are on different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that we are being accused of bias and working towards an undisclosed predetermined outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice, at least in the eyes and perception of the applicants. Consequently, and inevitably, each of us on this bench does hereby recuse him or herself from further participation in the hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. That's a decision that was made just when these petitions were ongoing. So, when allegations of bias and working towards a certain outcome are made for the Supreme Court recently, is recused itself. My Lord, I have a decision, an Indian decision. It's called State of Punjab versus Davida Pal Singh, which also the question of recusal was discussed at length. And again, I do not want to dwell. The whole decision is a very lengthy one. It's about 400 pages. But at page 9, paragraph 16, the court set a standard that is applied in determining whether a bench should recuse itself. And the test, I read, the test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. And the court went on to say, the court has to proceed observing the minimal requirements of natural justice, i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is anality and the trial coram non judice. Therefore, the consequential order, if any, is liable to be quashed. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resolved in favor of recusal. So that, my lord and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself, that doubt should weigh towards recusal. That decision will be shared, and then the court went on to quash some proceedings which had taken place and still have been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Debo was referring to. My lord, I want to make the basis as to where those provisions are obtained from. And those provisions are obtained from the IDA guidelines on conflict of interest in international arbitration. You will find that material is published by the I obtained it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining matters, situations of conflict of interest. And it has graded conflicts in several shades. The traffic light shades is green, is brown, and is the waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties, or with a manager, director, or member of the supervisory board, or any person having a controlling influence in one of the parties, or an affiliate of one of the parties, or with counsel representing a party. Going with the materials, if they are true, that was stated by my defense, then that situation has already arisen. And therefore, it is a good ground for abusing. Well, I don't want to take these materials will be circulated. There is much more in these materials that speak towards the use of the institution that is not. Thank you very much.
Sorry, counsel, does the court have the benefit of the authority that you have referred to, the Punjab case and the IBA guidelines?
The Indian and Supreme Court case.
Yes, and the IBA guidelines.
Your Honor, I wish to say something on behalf of the second petitioner in 565. If I'm allowed to proceed.
Who are you?
Can you see me?
Your name?
I'm Battle. I'm online.
What is your name? What is your name?
Chimodo Teresia Wanjiro Makazi from Chimboya.
Yes, proceed.
Yes, thank you. I just wish to support that application by just submitting that public perception is everything and it cannot be ignored. I wish to rely on Article 47(1) in Article 50 and more specifically in Article 47(1) is where it says that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And more specifically on the part that is procedurally fair. Yeah. If you look at the way the court has conducted itself, of course we are in no doubt that the court is competent enough to handle these petitions, but then again, on the issue of the procedure, we had raised an issue of service, and the court ruled that we should check all documents in the portal. Unfortunately, today, you could not access the e-filing portal. So what one is meant to wonder is why we were told to access documents online, and when we go to the portal today morning, it's not working. Therefore, there is this perception that perhaps there could be something going on, because at all material times, judges shall be impartial. And the issues being raised currently are that there is an issue. Sorry? Okay. So there are issues that have been raised that are raising issues to conflict of interest, whereby we have been directed by the applicants to note that one of the judge has a spouse who has been nominated or appointed by the President of Kenya, His Excellency William Ruto. And I think that is not a question where we should be giving out affidavits. I think that is a question where the judge, the honorable judge, should just come out and tell us, if this is true, then are you going to feel conflicted, so that we can, as petitioner, say, okay, proceed, or no, let's have a neutral bench. The other issue is the issue of another judge, Honorable Justice Murima, being seen. No, not the judge. I'm not saying the judge. I'm saying the spouse of the judge being nominated or appointed. That's the issue that has been raised by the applicants. And so we feel, of course, if this appointment was done, will he be able to attending a wedding ceremony? Kingi. So the issue is, and they are long-time friends, will he be able to disappoint a friend? So these are the issues that the public is asking, and it's the perception anyway. So in issues such as this, we say these issues are very important and they cannot be ignored. And there's no point of, if people are saying we don't want the bench, it's not so hard for the bench to say, okay, just let's go back to the Chief Justice, please appoint another bench. There's nothing wrong with that. We know the judges are competent enough, but then if the issue of conflict of interest is arising, then the best thing to do before we go to the substantive issues is to pen everything down and say that go back to the drawing board and appoint a new bench. That's all.
Yep, Mr. Lordship, my name is Daniel Banton. I do appear for the third interested party, World Democratic Movement Party, together with Mr. Kala. My Lord, I would want to say only one short thing and then allow Mr. Kala to conclude without repeating what has been said this afternoon. My Lord, in 2008, I was involved in the matter which time the Vice President of the country. I appeared before Justice Paul Kehat, and he immediately told me the second respondent is my personal friend, was my classmate in law school. I recused myself. I was sent to Justice when I appeared before her, and my Lord, she said, The first applicant, a renowned professor, is my personal friend and I recuse myself. My Lord, I ended up in an out-of-court settlement. I do ask Ms. Akala to conclude.
My Lord, my lady, I just make one submission that in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate, we find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute because the question is, and this is a question that respectfully I want to pose to the bench. Will you feel comfortable? Do you appreciate the fact that so far the events that have taken place, whatever determinations that you will arrive in this particular matter, and they are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Murima did not disclose a relationship between himself and Amason King, which is an act of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure by itself creates suspicion, apprehension in the minds of the applicant. The last question is, if Justice Murima decides to recuse himself, is it the entire bench that will recuse itself or only one judge will recuse himself? Because I'm convinced that inevitably Justice Murima must recuse himself. Thank you so much.
Your Lordship and my lady, my name is Akinka. I do appear for the third petitioner in the consolidated petition. Your Lordship, mine is just to put into context the Supreme Court decision in Dari and 5 others versus East African Development Bank. So Your Lordship, in that particular matter, I want to say that first of all it was before the Supreme Court, and notwithstanding the doctrine of necessity, the Supreme Court considered that the right to a fair hearing by an impartial tribunal was so sacrosanct that the Supreme Court did not even consider the doctrine of necessity. So I just want to read paragraph 26 where the Supreme Court said, what is undeniable is the fact that by resorting to this cause of action, the applicants are unequivocally accusing this bench of lack of impartiality, fairness, and integrity. Such an accusation against a judge goes to the very core of his code of office. Coming from a party to ongoing proceedings, such an allegation must strongly persuade the judge to recuse themselves. So that is what the Supreme Court said. So Your Lordship, in that particular paragraph, the Supreme Court is saying that if there is an allegation, especially because this instance is actually almost same to that, because there was a complaint that was lodged against that bench before the Judicial Service Commission. I have heard today that the first petitioner has already lodged the petition before the Judicial Service Commission. Your Lordship, I beg that you are guided by this decision in holding that the right to a fair and impartial tribunal is very key.
And let us know about the petition which has been lodged, because I don't think parties are aware of that.
Your Lordship, I think it is in the
A petition?
No, not petition.
What is it?
a complaint that was...
Don't mislead the public. There's a whole difference between a complaint and a petition.
Yes.
Don't mislead the public.
He is the one who has said petition.
Alright.
My name is Dr. Eboso from Biriga County.